check.
Said she was on her way, right?
Emma?
Yeah.
Yeah, she's run a few minutes late, but we just let her join whenever she gets here, I think.
Yeah.
Phone's on mute.
Yeah, she said, please go ahead and start without me.
Yeah, okay. Well, welcome, everyone. We appreciate you attending this seminar on FOSTA, How Congress Broke the Internet. Look forward to answering your questions and giving you some information about this new federal law that we're dealing with in a variety of ways. I understand there's some interest in this topic, so we decided to assemble a group of panelists that have some knowledge on all things FOSTA. Emma Lasana from Center for Democracy and Technology will be here, I understand, a few minutes late, but she will be on the panel and give us her views and opinions.
I was going to say that for today's performance, playing the part of Emma Lonzo is Ronnie London, who is our co-counsel in the case.
Yeah, I think the thing to do is for us to give us introductions, give the crowd some introductions, let everybody know who you are and what you do. Ronnie, you want to start in the end and go this way?
I'm Ronnie London at Davis Wright Tremaine. I work with Bob Corn Revere on mostly First Amendment litigation.
Bob Corn Revere, again, Davis Wright Tremaine. I've known Ricky for years. This is the first time we've had the opportunity to work together on a case. But I've been doing First Amendment litigation for a while, and this is the latest of the cases and in many ways one of the more important ones.
And I'm Lawrence Walters, Walters Law Group. We do quite a bit of First Amendment work and sexual freedom representation. Been doing it for about 30 years, and also general counsel for the Woodall Freedom Foundation. Bob Corn Revere and Ronnie London and I are also counsel of record, as many of you know, in the Woodhull versus United States matter, challenging FOSTA. Thank you. And we're very proud to represent Woodhull in that case, particularly as the first group to come out and challenge the law. It took a lot of courage, and we're very happy to be representing Woodhull and the rest of the plaintiffs in that litigation. I mention that because there are some restrictions on what the lawyers that are counsel of record in the case can actually say in connection with the litigation strategy and probable rulings and things like that. So I know you'll have some questions. We hope to answer all of your questions, but to the extent that we have to pass or not answer a question, it's not because we're trying to avoid or anything. It's merely we're trying to honor our professional obligations.
Exactly. So. Among other things, we won't be able to get into specific legal advice that we have been asked or that we've given to Woodhull or to any of the other plaintiffs in the case.
And the mics are not.
Oh, okay. As I was saying, we won't be able to get into specific legal advice that we've given to Woodhull or to any of the other parties in the case. But we will be able to talk about the context in which the law was passed, what the issues are in the litigation, and hopefully to answer questions that you have.
Okay. And with that, I thought it might make sense to start with, how did we get ourselves into this mess? And, what caused all this to happen? And then we'll start digging into what the law did, how it changed the current law, what the effects are, and what the future might hold. But starting from the beginning, Al Gore invented the internet, a series of tubes, carried messages all over the world, and platforms needed to develop in order to allow people to find each other and categorize messages and send messages back and forth. And so these early platforms were news groups, as many of you may remember, and that morphed into MySpace and Facebook and Google and YouTube, and you know the rest. So these platforms, after a while, began to get nervous about the user-generated content, about the illegal activities or illegal content that might be uploaded by users. And the government also started looking at platforms as a potential target for the enforcement of criminal law. The law enforcement is used to prosecuting people who assist others in committing a crime. They call it aiding and abetting or facilitating, and they're not used to giving people a pass, and so they looked at some of the early internet platforms and decided, there's something we got to do about their role in making illegal activity available. One of the earliest cases was the BuffNet case in Buffalo, New York in 1998, where law enforcement went after some users of BuffNet, which operated some news groups. One of them was the Pedo University, and law enforcement took an interest in that news group, understandably, and prosecuted some of its members for child pornography violations.
And please welcome to the panel
Emma.
the lovely Emma Alonso.
Emma, we were just talking about you. Let me take 1 second and allow Emma to take a breath and let her introduce herself so you know who she is and what she does.
Hi all, so sorry for being late. A combination of challenges with Lyft and challenges with the building. But my name's Emma Alonso. I'm the director of the Free Expression Project at the organization, the Center for Democracy and Technology, which is a nonprofit advocacy organization based in Washington, D.C. and Brussels that fights for freedom of expression, privacy, and security online.
Thank you. Appreciate that. We look forward to your comments. Emma is not similarly constrained in what she can or can't say about the lawsuit, so you might hit her with some of those questions if she decides to answer. All right, so we're talking about the early prosecutions against online service providers or platforms. We use a lot of different words for it. Online intermediaries, internet service providers, interactive computer services. It all means the same things. Platforms that allow people to communicate. And so after the individuals were prosecuted in the BuffNet case, law enforcement went after them for knowingly assisting people in downloading and transferring child pornography. They ended up pleading guilty, so none of the issues were resolved about whether they were actually liable for user-generated content, although theoretically they could have asserted a defense under Section 230 of the Communications Decency Act. Do any of you or all of you know what Section 230 is?
Actually, why don't we do a little bit of that background, because it really is essential to a discussion of the law that was adopted in FOSTA. And we can debate whether or not it's FOSTA or FOSTA. I'll just say FOSTA. And we're not doing any of that SESTA business. That was one of the legislative proposals that led to it. When the law finally got adopted, it was just the acronym FOSTA. And besides, I try and limit the number of acronyms being in a Washington practice because it just gets too confusing. Anyway, the background for this law is that since the mid-1990s, since the emergence of the World Wide Web, Congress has had sort of an uncertain relationship with how to treat this new technology, what was then a new technology, and how that fits into a scheme of freedom of expression. It was the first time a technology like that emerged sort of unbeknownst to Congress. It sort of was there, and then Congress had to figure out what to do with it. And so its first official action, the first legislation dealing with the Internet, was, of course, to censor it. It was the Communications Decency Act, introduced originally as an amendment, as a section of the Telecommunications Act rewrite in 1996. The CDA part was introduced by Senator James Exon of Nebraska, and it would have prohibited any transmission of indecency on the Internet. Hard to imagine, but it would have treated the Internet like broadcast radio and television, where the indecency regulations were adopted to prohibit George Carlin's 7 dirty words and anything associated with them. So that was how we were going to treat the Internet once Congress became aware of it. That passed almost unanimously by Congress, and fortunately the Supreme Court struck down that section of the law in 1997. Section 230, which is that section of the CDA that remains, was proposed as something of a countermeasure for Senator Exon's censorship proposal. It was introduced in the recognition that online platforms wouldn't long survive if they had to be responsible for anything that anyone would post on those platforms, and there would be no robust exchange of ideas on the Internet if you didn't have some kind of immunity. There had been some lower court cases and state court cases involving defamation that were beginning to be threatening in that area, and they became one of the things that this provision was designed to deal with. But more broadly, it was designed to be a counterweight to the Exxon proposal. Congress, being Congress, decided to adopt both of them, and so the censorship provisions were the part that was litigated in the Supreme Court. Those were struck down, and the Section 230 part remains. People often get confused about that because they say, how could something called the Communications Decency Act immunize people for posting all of this terrible stuff online? Well, it's because the Communications Decency Act name came from the Exxon part of the bill and not from the CDA Section 230 countermeasures that were adopted. it became almost inadvertently the most important legislative enactment supporting Internet freedom that has ever been adopted. And because of that, it has been the subject of continuing debate, continuing proposals to amend it, and ultimately, because of cases involving Backpage and others, the political momentum finally built up to the point that this year Congress did adopt FOSTA, which includes amendments, the first amendments, to Section 230.
Yes. So essentially what we're left with is the Communications Decency Act being invalidated as to the indecency part, but the good part of it, allowing for immunity for online platforms, remains. And that essentially fueled the development of the Internet because platforms didn't have to worry about being sued in every local jurisdiction for any illegal activity or content posted by their users. And that really generated the user-generated content business model like Facebook, Google, YouTube, et cetera. So law enforcement originally looked at these online platforms as helpful sources of information when it came to illegal activity. They realized that there's nothing we can do to prosecute them under Section 230 at the state level, so they can be helpful in finding information about illegal activity, including things like IP addresses and credit cards and photographs and so forth. And so there was a relatively cooperative relationship with a lot of the online platforms and law enforcement. Some law enforcement referring to them as a treasure trove of information or a honeypot, place where criminals can go and leave information that law enforcement can find. And so that worked for a while until around, I'd say, 2009, it started to change, and the state attorneys generals started looking at the online service providers, particularly those that posted escort ads or adult personal ads, as the cause of the problem instead of a partner in helping to solve the problem, and began blaming these sites for the proliferation of sex trafficking and or prostitution. So the AGs ganged up on Craigslist and put a lot of pressure on them. There was some litigation which Craigslist was pretty much winning, but ultimately Craigslist stopped publishing personal ads, adult personal ads, as a result of the public pressure, and that void was filled by Backpage primarily. And Backpage then became the focal point of the AGs who were trying to enforce state law but had no way to do it. And so that resulted in all these calls for amending Section 230. We've got to find a way to put Backpage out of business. We've got to shut down rampant prostitution and alleged sex trafficking that is occurring online, and we can't do it because Section 230 is preventing us. Now,
just to make one point about that, though, Section 230 does not prevent the enforcement of criminal laws by the federal government. So there was always a tool for law enforcement at the federal level to even go after the websites if they chose to. And the fact that they didn't use that and let it instead wind up being the evolution towards FOSTA is part of the problem.
Yeah, funny you say that, because in the next couple slides is proof that they could pursue online escort advertising sites or online service providers that publish adult personals. The escorts.com case dating back even to 2011 shows that. The federal government raided A1 advertising, A1 national advertising, and ultimately through a plea agreement seized escorts.com and shut it down for violation of federal law, alleged money laundering activities. So, right there is proof dating back to 2011 that they had tools at the federal level to shut down escort advertising sites that are violating the law under federal law, because Section 230 doesn't apply to federal law. And it went on from there. My Red Book was next on the chopping block in 2014. This time the government got more aggressive, and instead of working out a plea agreement, they came in and just simply seized the website as soon as the operators were arrested and shut it down. Ultimately, the operators negotiated a plea, so there were no legal issues resolved as to whether or not there was any protections associated with this type of activity or maybe even any Section 230 issues. But My Red Book was immediately seized when the operators were arrested without proof of guilt beyond a reasonable doubt, and the violations of federal law supported that seizure. Next, they came for Rentboy in 2015. This time, the Department of Homeland Security was involved, and they alleged violations of the Travel Act, other federal laws, ultimately money laundering allegations. The the case was brought against all 10 employees, and all those employees were dismissed, but the owner ended up negotiating a plea agreement and spent 6 months in prison, I believe. But again, federal law was used to shut down a site that was allegedly involved in online prostitution and sex trafficking. They even went after a website, an online escort website at the state level, the reviewboard.net, although the Department of Justice and the FBI were involved. This one in 2016, this was a group of hobbyists that set up a online review site and was prosecuted ultimately in the state of Washington and pled guilty to prostitution-related offenses. Backpage itself took down its adult ads after some mounting public pressure and a Senate report that came out in 2017 that alleged that it was involved in changing some of the ads or moderating the ads in a way that they believed was a violation of federal law. And Backpage had been pursued by various law enforcement agencies, including Sheriff Dart, and Bob, maybe I'll tell you a little bit about how that came out, but the Sheriff Dart tried to stop Backpage from using credit cards and essentially pressuring the credit card associations to stop them from doing business with Backpage, and Bob obtained a tremendous result from the Seventh Circuit Court of Appeal and stopping that practice or finding it to be an unconstitutional extrajudicial act. But the cost of trying to fight all those battles resulted in Backpage saying, you know, this is forced government censorship, we can't fight this fight anymore, and took down their adult ads. Some of the advertisers went to the dating section of Backpage, and so the critics were not happy yet. They still wanted Backpage to be taken down and kept arguing, we need a new federal law to take down Backpage. Well, of course, there's already laws. They took down all these other sites, so the argument never made much sense, but they kept making it, particularly the state AGs who wanted a piece of the action and wanted to be able to prosecute and you know, essentially get some headlines and do their part in this battle against sex trafficking. Ultimately, FOSTA and SESTA were passed. FOSTA passed the House in February of 2018, and the votes on these laws weren't close. It's hard for lawmakers to actually, you know, stand up and vote against an anti-sex trafficking law, but it passed. It passed the Senate in a 97-2 vote, and ultimately became law. Before it was even signed, Craigslist gave up and eliminated all of its adult ads, all of its dating ads and personal ads completely, and shuttered the entire section, stopping many voices from being heard. And simply as a result of the fear of potential enforcement of this law that hadn't been signed yet. But again, the potential breadth and scope of the law, as we'll talk about, increased the liability of potential website operators so greatly that they couldn't take the chance of continuing. This is just a list of some of the sites that were closed right after FOSTA was signed. It wasn't even made law yet, but numerous websites were shut down as a result of the passage of FOSTA, including online verification sites that would simply provide verification of the identity or information of people, potential customers, and adult service providers, and review sites that provided review and safe date information for sex workers, safety information. All of it was shut down. This is just a short list. There were many others that shut down once the law was passed because they realized the potential new scope of liability that they'd be facing. Before, again, the law was signed in April, Backpage was raided by the federal government, and the DOJ caused the CEO to essentially flip and agree with the government to turn over Backpage and seize it so that it would be shut down completely. Again, all before FOSTA was ever made law. So all of the efforts, all of the rhetoric, all of the claims that we need a new law, we need a change in Section 230 in order to take down Backpage was proven wrong when they took down Backpage before the law was passed. There's the signing ceremony on April 11th. FOSTA finally became law. And
can you go back to that last night?
Please.
Because if you look at the faces of the people standing behind Trump, you can tell that there are a number of them with looks on their faces like, what the hell am I doing here?
It's worth mentioning also that in the Backpage litigation, the criminal action against them, all of the charges are for facilitating and promoting prostitution. There are no trafficking charges in that case.
And that's the same with all of the cases that have been brought against the online escort advertising sites that I mentioned. They were all hyped as sex trafficking operations, and we need to go after sex trafficking, and never did they charge any of them with sex trafficking. It was always some sort of consensual prostitution charge or violation. In the Washington case, there was even an allegation that a certain advocacy group was making substantial donations to the King County prosecutor in order to bring these cases and label them as sex trafficking operations, even if they were only prostitution, so that they could further their own mission and make claims of sex trafficking when none exists. But
well, and that's actually an essential part of the problem, and it's part of the problem with this new law in that it automatically conflates consensual sex work with trafficking, which is like confusing farm working and slavery. It's, they're completely different things, and yet they're treated the same under the law.
Yeah, so we should get into exactly what the law does. This is just another list of the many different impacts that FOSTA had even before it was passed or shortly after it was passed. Some of it is impossible to prove. Some of the companies deny that FOSTA had anything to do with, for example, taking down the erotica titles on Amazon from the Kindle store. Even though it happened the day after FOSTA was passed, they claimed that there was some kind of update to their Kindle store that temporarily readjusted and delisted some titles. But all of this is very uniquely timed to coincide with the passage of FOSTA or its execution, and has resulted in a significant impact on abilities of people to get access to payment processors or storage facilities or information on sex worker safety, et cetera, even use of Airbnb. So we're getting into FOSTA now and what it does. Bob, you want to take this one?
Sure. The law made three essential changes in federal law. One, it adopted a new provision that created a new offense for anyone who owns, manages, or operates an internet computer service with the intent to promote or facilitate prostitution. It changed the law involving trafficking to make it easier for federal prosecutors to prosecute for participating in a venture that could lead to trafficking. And then it made changes, as we mentioned earlier, to Section 230 by cutting back on some of the essential immunities from state criminal prosecutions under local law, if it's like the new provision of federal law that promotes or supports prostitution, state prosecutions can be brought under corresponding state laws there. State prosecutions can also be brought under corresponding anti-trafficking laws. And then now it also allows civil actions to be brought for essentially the equivalent of trafficking charges, where the civil litigant, the victim, is claiming that they're harmed by a platform assisting in trafficking.
And when this was all being discussed, the initial proposals were simply a change to Section 230 that would allow for easy prosecution at the state level of website operators for sex trafficking offenses. And there were various competing proposals and so forth, and until the Mimi Walters Amendment, no relation, by the way, it came out and essentially proposed this brand new federal law that would make it a crime to promote prostitution online, which, by the way, promote or facilitate or even prostitution are all undefined.
Well, and Emma and CDT were very involved in the legislative process in trying to deal with and head off those changes. Do you want to talk a little bit about that?
Sure, yeah. So the legislative process that kind of led to the law that we have that was passed as FOSTA is a great example of how messy legislation and lawmaking can be in Congress. As we've talked about already, the final bill that was passed into law is this weird hybrid, or as one law professor and Section 230 expert Eric Goldman calls it, the kind of the worst of both worlds. There was a proposal that came up in the Senate. There was the proposal that that came up in the House and the Walters Amendment, kind of creating, not just amending Section 230, but creating new, very vague federal criminal law about facilitating prostitution through all manner of activities. And Congress, in its infinite wisdom, looking to find kind of a way forward, ended up combining the two bills so that we got not only the kind of the carve-outs to the protections from liability that website operators and other online intermediaries had enjoined, but also this brand new kind of strong federal criminalization of a really vague set of activities that have anything to do with prostitution, which I think just for, from the free speech perspective, substantially amped up our concerns about the impact that this law would have. It was a challenging legislative discussion because we had, I can't tell how many conversations with staff on the Hill working for members of Congress who, you don't think of as necessarily, trying to be crack down on all kinds of sex work everywhere, or, whom you might think might be more sympathetic to some of these arguments. But routinely, the message that we got from staffers was, I get the points that you're making about the impact on free speech. I get how this bill is going to make it extremely risky for website operators or payment processors or anybody else to do business with anybody having anything to do with sex and sexuality, let alone prostitution, let alone trafficking. But still, my boss can't vote against this bill. And just consistently the message, like, even if they agreed with us on all of the concerns we were raising and knew that the bill that they were signing on to was potentially massively overbroad and unconstitutional, the political hit of being against fighting sex trafficking was too much for practically anyone to stand up against.
Yeah, and part of the concern here is that this law targets speech. Now, obviously, prostitution doesn't occur online; it has to occur in the real world. So the only thing that this law prohibits is the speech that's associated with the act of prostitution in some way, if it occurs online. And when you think about the breadth of FOSTA and all the things it could apply to, operating an interactive computer service. I mean, sending an email, sending a text, storing something in the cloud, posting something to a website. Everything requires the use of an interactive computer service in the modern world when you interact online. And so that the target of the law, the target of the prohibition, is the speech associated with some sort of undefined, amorphous prostitution activity. And then you get into issues of facilitation and promotion, which are likewise not defined. Nobody really knows what it is that would trigger a violation of FOSTA. We know that you have to use a computer service somehow, and you have to do something that's somehow associated with prostitution. Other than that, it's extremely broad, and the natural result of the companies that have to deal with this, the platforms, is to over-censor, is the chilling effect. They can't take a risk given this undefined, overbroad law of veering into the danger zone. So they have to cut off their liability by censoring around the edges and taking down content that relates to sexual activity. And that's the danger to sexual freedom, and that's what we have grave concerns with.
Yeah. One of the interesting things about the litigation, as you know, we filed suit on June 28th. We've had one session in court, and the government's position in this case is really very interesting in that one of the points they make repeatedly, both in their briefs and in oral argument in front of the court, they say this law has nothing to do with speech at all. And you try and explain that it's about nothing but speech. It's really all the internet does. And one easy way to tell that is if you just read the language of the law and you insert the word printing press where it says interactive computer service. Now, no one would question that law was about freedom of the press, but sometimes you have to just re-educate people or educate them in the first place, I think, in this case, that this really is about nothing but speech.
And the slide that we have on right now talks about the expanded liability for aggravated violation of the prostitution law. So there's another way you can violate this law, that makes things worse. So essentially, if you promote or facilitate the prostitution of 5 or more persons, or you act recklessly in connection with sex trafficking, then you can be sued in civil liability, and you're subject to a potential 25-year prison term. Now, I don't know how many websites have fewer than 5 people on them. It must be a really crappy website if it does. But if you're posting content on a website, it's going to involve more than 5 people. So this is a meaningless distinction. Essentially, it's a 25-year felony for any promotion of prostitution on a website. And then secondarily, you can be held similarly liable with massive potential mandatory minimums and up to life sentences for sex trafficking violations under Section 1591 if you are acting in reckless disregard of sex trafficking. So that means you don't even know, you don't have to know what's happening. If it happens and you should have known, or you should have done something different, or you turned a blind eye in somebody's view, then you can be held liable as a platform for violation of this law. So it creates a tremendous expansion of the previous liability that website operators had.
So you begin to understand that long list of sites that have changed their policies or have shut down because of concern that these provisions could be applied to them.
And kind of as Larry was pointing out, that no website that really merits the name website has fewer than 5 users. This whole question of the scale of online content is really, really crucial to understanding why so many of the online services have responded in the way they have with shutting down either their entire sites or portions of their site. Because there's and this is one of the kind of the fundamental motivators for Section 230 and the broad protection that it's provided to website operators for the past over 20 years. There's no way for a website operator to review all of the material that people are posting on, say on the Craigslist adult services section, right? There was no way for Craigslist to manage that sheer amount of information that was being uploaded to their service every single day. There are just too many posts to actually do that in-person review. You think about Facebook with literally billions of posts going up a day, or YouTube with 400 hours of video uploaded every minute. The kind of pre-publication review that a website operator would want to do to avoid being considered to be recklessly disregarding something is just not functionally possible the way it might have been for a book publisher to do, or even a newspaper editor editing articles. So when you face these kinds of issues of scale, website operators are kind of put in the position of, they can't, it's hard to make individualized determinations that are really successful in balancing a lot of challenging competing interests and dealing with the fact that they don't, at the end of the day, really know who is uploading this content. And they're not really sure, this person's putting up an ad for a massage parlor. Is that a massage parlor that's a massage parlor? Is it a massage parlor that provides sexual services too? Is it a massage parlor that's the front for a trafficking ring? There's really not a great way for the website operator to know that. And as we keep mentioning, the response when the threat is potential criminal liability or state prosecutors and seizing, the answer is going to be nobody can advertise about massage at all, and just try to keep everything at arm's length.
And the inability to know the state of mind of a user is critical here too, because trafficking involves either underage individuals or unwilling individuals, coerced individuals. And so platforms are put in the position, if they want to avoid sex trafficking allegations, of divining the actual age of the person that's subject to the advertisement or the content, and or their state of mind, whether they happen to be posting this content willingly. And in working with a variety of folks in this field, it's you have to essentially be in the room and talk to their coworkers and parents and friends to determine what their state of mind is. The internet, as Emma said, doesn't operate like that. The scale is tremendous. These ads are posted very quickly, and it's virtually impossible to know the state of mind of an individual, let alone the age. Congress has tried to impose age verification requirements on many occasions on the internet, and the course technology is not there to determine the physical age of the person behind the keyboard at any given time. For purposes of online liability for sex trafficking, that's the obligation. You got to know that the person's overage, and you got to know that they're willing to engage in the activity in order to avoid a sex trafficking allegation.
No. This is just getting into some of the more specifics, but I think we've pretty much covered these. Except one point that, and Ronnie had mentioned it earlier, and it's right there at the bottom, where some of the changes to Section 230 apply retroactively, which means that even if the activity took place before the change in law, that under this provision as written, that it would apply in any event. Despite the change in law. Now, this part is so unconstitutional that even the Justice Department wrote to the House of Representatives and said, you know, guys, there's something in the Constitution called the ex post facto clause. You're not supposed to pass laws that apply to people before the law was passed. And yet they adopted that part of the law anyway.
The scope of this retroactivity is actually breathtaking because it's retroactivity for civil causes of action for victims of trafficking, but it's also retroactive for state law enforcement for violations that mirror the facilitating prostitution and the sex trafficking in 2421 and 1591A, which is fascinating, especially for 2421A, because if you committed a violation before the effective date of FOSTA that would have violated 2421A, you could be liable for criminal penalties in state law nonetheless, even though at the time you acted, there was no such statute even on the books.
First-year law students learn early on that that's a violation of due process, and the Justice Department told them it's a violation of due process, yet there it is in our new law.
And, I mean, it was very clear that members of Congress knew this provision was in the law when they passed it. This was not a surprise, but it was another example of just how messy the sausage making of legislation is. By the time that the Justice Department sent the letter saying, in general, they were supportive of getting more power, but that they did want to point out this one part of the legislation that was definitely unconstitutional. The kind of the deal making in Congress was such that nobody could suggest any amendments to the bill that was going to go up for a vote. So even though you had a letter from the Justice Department saying this particular clause we would suggest taking out, it's a bill about giving DOJ and other law enforcement agents more power. You'd think Congress would be responsive to what DOJ was asking for. But at that point, the idea of reopening the kind of the legislative package, that deal, and taking anything out was not something that anybody involved, any of the members involved, felt they could do. So it's another of the kind of the unfortunate pieces of this process that you can get far enough along in a legislative process that very reasonable arguments, very thoughtful discussions and advocacy make not a dent because the politics of it have kind of been settled, which is why it's so good. We have the option to challenge things in court.
Yeah. And it wouldn't have been a complicated change either. It was one self-contained provision, subsection like D or whatever it was, and just strike it through. It would not have been hard.
Yeah, and speaking of the politics, I mean the politics of FOSTA was, we've got to hold these platforms responsible for sex trafficking, rampant sex trafficking that's occurring. But many of us in this room know that that wasn't the real agenda. The real agenda was to eliminate consensual sex work as well as erotic material online. It's the same people pushing FOSTA that used to be morality in media and the censorship crowd that were trying to sell America on a war on porn, alleging that it's addictive, and there's pretty much laughed out of the court of public opinion, and America wasn't buying what they were selling. And they realized that we've got to change our message, we've got to go at this a different way. And so they decided, we can conflate sex work with porn, with sex trafficking, and who can vote against that? Save the children, save the...
And many of these organizations have rebranded.
They absolutely have. Morality in Media has rebranded as an anti-sex trafficking organization, and so that's what they do now. And this is an effort to eliminate sexually oriented material from the internet. And then they knew from the beginning that if they prohibited online promotion of prostitution, that the large companies would have no choice but to over-censor, but to engage in what's known as the chilling effect and eliminate anything that's close to the line. And so they get their end result through a different way that is more politically palatable to the United States at this point. Brilliant, huh? You know,
All political, finger from the right wing,
yeah.
the Christian right.
It's not just the right wing.
It's bipartisan.
It's bipartisan in the scariest sense of that term. You know, it's another example of how everything that politics touches diminishes or destroys. But this is something, particularly for the anti-trafficking advocates, many of them are progressives, but they are joining forces with traditionally right-wing folks, and all of them advocating that this be adopted. And it's one of the reasons why, as Emma said, this was simply politically irresistible. You couldn't persuade a member to oppose this, even if they knew. And I'm not. She probably has a better sense that some of them actually understood what they were doing than I do. But even those who knew that this was unconstitutional wouldn't have cared.
And as Ricky put it last week, this really is the camel's nose under the tent because, you know, for a long time, Section 230 was just an absolute line, you know, thou shalt not pass. And now you've got a doorway in through Section 230 for trafficking and facilitating prostitution. And so once you've got a breach, whether it's a door or whatever it is, well, what's a couple more windows? And we've already had, just this past week, Senator Warren, I really like platforms like this amendment to say, oh, well, there's an exception to the immunity for user-generated content. It becomes that much easier to try. There's another exception we should do. Another.
And we think about the policy issues that are coming to the fore these days. Obviously, that's one of the Europe is dealing with it. Germany has ongoing platforms to be responsible for taking down, quote, fake news. One of the many problems is, who's going to charge of determining that? Is this the kind of power you would want to give to the person currently sitting in the White House of determining what is fake news and giving him the legal tools to decide what should be allowed and what shouldn't be, making the platforms responsible legally for making that determination and creating consequences if they don't do the right thing simply chills all speech online.
And I really want to underscore the kind of these points about the further threats that we all are going to see coming up in the kind of the realm of regulating social media or regulating the internet. I think one of the big challenges that we, and I'm thinking, kind of speaking as part of the tech community and the digital rights community, I think one of the big challenges we faced in fighting back against FOSTA and FOSTA was that, you know, the arguments about it's important to keep an open internet open, it's important to champion free speech online, do not work as well as they used to. There's an awful lot of people who see, you know, 25 years of development of the open web and aren't really that excited about what they see because there is, you know, legitimately harassment online, there's hate speech online, there is fake news, however you determine that, and disinformation. There's a lot of concern over what is the internet capable of, or what are people capable of doing with the internet and these technologies. And the mood in DC, absolutely, and in Europe and in many other places, is very much skepticism of the big internet platforms, which, you know, I think they earned a fair amount of that. But unfortunately, it's skepticism of kind of using the internet for openness and for free speech at all. And I think that is a really bad position for all of us to be in. There's more of a momentum today to think about ways to make all website operators, not just Google and Facebook, but anybody running any part of internet infrastructure, liable for user speech. And we know that's going to mean fewer opportunities for everyone in this room and for so many people around the world to put their message out and to express themselves.
But it's not just skepticism about free speech online. There's an active debate and a lot of skepticism about the very concept of free speech. One of the other areas that I work in a lot, and Ronnie and I work in together a lot, is on campus free speech issues, and about a lot of the pushback on how much free speech there should be allowed. You know, there again, you have a lot of people arguing that too much free speech is bad, that it means that hurtful things can be said, that speech can be very harmful, and that gets magnified when you talk about the online issues as well. One of the best things about the internet is it allows anyone on the planet to be a speaker to the world, and one of the worst things about the internet is that it allows any individual to be a speaker to the world. It means that any sort of ugly or hurtful thing can be said. There are legal limits, but that's where the debate lies. How far do you allow that to go? For years, in the wake of the first battles that we fought over internet free speech, Emma's right. It was pretty much an easy sell to say, whatever you're proposing is going to harm free speech on the internet. And that would tend to back people off. But these days, when people are arguing and debating the merits of free speech as a concept, it's difficult, and it's even more difficult in the tech community since those issues get transplanted and applied to the online world.
And one of the other dynamics that we saw is that, having the sort of the fight be between anti-sex trafficking on the one hand and free speech on the other, also doesn't really convince a lot of people, right? There's, to First Amendment advocates like, the people on this panel, that means a lot. Threatening free speech is a visceral issue. I think just frankly, it doesn't strike most people, and certainly not most members of Congress, quite the same way. And what we didn't have was nearly enough focus on the actual people on the other side who were opposing SESTA and FOSTA because of what it would do to them and their lives, their livelihood, and also just their very safety, able to get their message and their voice and show that this wasn't an issue of, horrific, the worst possible examples of, child sex trafficking on the one hand and some people being censored on the internet on the other. This was actually a set of harms kind of across lots of different experiences and perspectives, and that what Congress was doing was kind of making a hash out of doing something that would help anybody be safe from harm. So I think in the future debates that we have on these issues, and they are coming, and kind of sexuality and sexual freedom issues are going to come up as at least casualties of whatever happens with political advertising or with, concerns about bot networks and the way that that's driving people to suggest we need a lot more identified speech online and less room for anonymity and kind of privacy protections. All of these different kinds of things that are, a couple steps away from sexual freedom issues are still going to end up having a huge impact on what is the space online for discussions of sex and sexuality. So the more that we can do now to be cataloging what are the effects of something like FOSTA, what are the real chilling effects that are out there, and chilling effects are by their nature very hard to pinpoint and say, we can draw a straight line from this law being passed to this thing not being said. It's a challenging thing to demonstrate. But if we can get, the stories out there of the websites that are shut down, but also the partnerships that people don't enter into to, put content online, the websites that don't get launched, the dating services that don't can't offer people to connect to each other. Those are going to be really important to have concrete examples that we can bring in the next rounds of these fights, because without kind of faces and the opportunity for empathy for the people who are being censored already by laws like FOSTA, it's going to be very hard to make that case in the next battles as well.
Well, and when you're talking about, future debates on this, I can tell you in the wake of FOSTA, we've had a number of some of the largest internet ecosystem providers come to us and say, all right, so now what do we do in terms of internal policy on how to deal with FOSTA? And, well, that's a significant problem when you're dealing with such a broad and vague law, is that you can't really develop internal policy other than erring so far away from what could possibly fall within it that the reaction is, well, we can't do that. That's too big a chunk of what we do. And they say, well, what should we do about this? And my answer sometimes is you get frustrated, and these are smart people on working teams trying to do real business, and you say, really what you should do is get yourself a DeLorean, slap your Mr. Fusion on top of it, go back to 2017 and stand up to someone, because some of the biggest companies in the world that this is going to affect really didn't do enough, like you're saying. And, it's too late now, but when it comes around again for the next issue, they need to be reminded that they didn't do enough this time so that they do enough next time.
Yeah, it's the fact that the Internet Association and Big Tech was originally opposing the bill, and then suddenly saw the light and decided to to support SESTA and then FOSTA was really the death knell of the opposition, it seems. And it occurs to me that the sex worker community was not aware of the pendency of the legislation early enough and didn't know. I saw some mention, but I think it took that they didn't really realize how serious this was and how serious until the law. And I think that they're going to be regretting their decision to let this one go because they're going to be subject to the next exception to Section 230 or they decide to do. They've let this one go.
Well, and it's like you said. I mean, originally this was a bill to amend Section 230. The stuff about, facilitating prostitution or reckless disregard, I mean, that 2421A got added pretty late in the process, and I don't think that was just happenstance. I think there was a design there.
But yeah, the Senate version of the bill was introduced just about a year ago, and groups like CDT and EFF and a lot of the kind of civil liberties groups had been advocating all throughout the fall, but also for years before this. That's another thing I think to take away from this. FOSTA was years and years and years in the making, not the specific language that got passed into law, but as I think we were talking about earlier, state attorneys general started trying to pressure Craigslist to take down their adult services section back in 2007. This is a long-running campaign and kind of a long-running effort. So there was, it's hard to gauge how much awareness different groups or communities had about this issue because it was also this sort of ever-present kind of threat that something like this might happen. But what was really striking to me as, an advocate who had been publicly opposing this particular bill and legislative process, for months was that it wasn't until the bills passed both houses of Congress, and we had this strange month-long period before President Trump actually signed the bill, and it was in that month period that I saw more press attention than anything, right? And sitting there as an advocate who's been trying to develop campaigns and drive things like this. I mean, I'm glad you're paying attention now, and I'll, talk to whoever wants to talk to you about this, but we needed that kind of attention back in September, October. Not having it come in March was much, much too late to influence anything. But part of where, at least, in my capacity as somebody who talks about tech issues, most of the media requests or the other kinds of contacts that I got about the law were coming after we saw websites taking action, after Reddit closed down some subreddits, after Craigslist shut down some sections of their site. And it was just such a good reminder that the visibility of a name, a household name website like a Craigslist or a Reddit taking some kind of action seemed to get more press attention than months and months and months of other advocacy efforts that a lot of us had been coordinating on. So as far as how we can try to draw the tech industry back into these fights, make sure that there is, support for not just for their commercial interests, but really for the speech interests of their users as we go forward, that's something that we're going to be focused on a lot.
Yeah. And the thing that has not been fully reported yet, although you will see articles about it in some places, is that all of the well, I was about to say horror stories, but all of the negative attributes of FOSTA that were predicted at the time it was set to pass have really happened. It has been a real adverse effect on the ability to investigate trafficking. There have been some articles about how law enforcement finds that it no longer has leads for rescuing victims and stopping trafficking because they don't have the classified ad websites that they could previously use to subpoena and to use for testimony where there were actual examples of trafficking. Sex workers have been drastically harmed by closing down of sites, forcing some women out onto the streets, closing down the ability to have various harm reduction sites available. And there has been no decline in trafficking because the sites that were closed down have been replaced by sites located offshore and by other replacements. And so the law has had none of the beneficial effects that it was touted to have. It has had the adverse effects that were predicted, and it has led to widespread censorship online.
Not only did it not reduce sex trafficking, but it's widely suspected that it's increased sex trafficking in that sex workers who were previously able to be independent and operate their own website or post their own ads were then driven into the hands of dangerous people and being required to be trafficked, essentially. So you're seeing an increase in the activity that Congress was trying to decrease. And as Bob said, the same content, the same ads can be posted on a server in some jurisdiction that the United States can't control. So that the idea that you'll be able to stop online escort ads, online sex worker ads is a panacea that's simply not going to happen because of the worldwide nature of the internet and the limited jurisdiction of the United States.
I think we have some questions.
Yeah, and we want to make sure that we leave enough time for questions and spark some discussions, I'm sure. So any questions out in the audience? In the back. The question was, since this law now allows victims of sex trafficking to sue for violations, how many victims have actually received checks? To my knowledge, the answer is 0. It is a fairly new law, so theoretically claims might just be getting started, but I would not be surprised if we see a multitude of claims against those who continue to operate in the industry and work in the danger zone, so to speak, because you have numerous advocacy organizations that are ready to go and chomping at the bit to litigate these issues, to establish precedent, and to obtain money. There are the ability to obtain restitution and attorney's fees in this law, and so there's a real financial incentive for private lawyers to file lawsuits on behalf of victims of either prostitution or sex trafficking.
And there are nearly 24 cases around the country where they have tried to use civil actions, whether it's under FOSTA specifically, and some have, or whether it's under other laws now that they've been unshackled from the 230 immunity, to try and bring suit. And all of those are kind of slowly trickling along. It's just like the challenge to FOSTA. The other litigation is a slow process also. But those cases in their early stages, and in the past where those cases might have gotten dismissed very early on in the case, they're instead hanging on now. And in those cases, there's anywhere from 1 to 3 or 4 or 5 individual plaintiffs, and in some cases there are actual interest organizations that are the plaintiffs saying, you've injured us because we've had to use so much of our resources to provide services to our clientele who have been trafficked or otherwise injured, so you need to give us, the organization, plenty of money as well.
I think that's one of the concerns about how effective will the civil recovery provisions in FOSTA actually be. How many actual victims will ever get checks from anyone out of this is unclear. How much of that will go to organizations or attorneys' fees or others who are kind of see the opportunity that's now been put in the law to get money out of website operators and use that for their own benefit versus actually being something that's targeted at getting resources to actual victims of sex trafficking who need them.
Well said. Nina, I think you had a question? Yeah, so the question is, can the U.S. government actually do anything about the foreign sites that are taking over some of the ads and some of the content, since ICANN is a U.S.-backed and kind of launched organization? The answer is essentially that it's sites that are located within the United States registry, within a registry that is in the United States, .com, .net. There are a number of registries, top-level registries that are in the U.S. The government now has learned to go directly to the registry to shut down a website, to enforce a seizure order, and so forth. So they can shut those down. But domain names, top-level domain names that are located in other countries are not going to be able to be controlled by the United States government, like a .ch for Switzerland. You see, a lot of people using protonmail.ch. those servers are all outside the United States, and at least that company says we don't respond to U.S. demands. We operate under Swiss law and Swiss privacy laws, and so it'll be interesting to see how much pressure some of these foreign countries are willing to take if they are asked to shut down a site. But the United States cannot shut them down because they don't have jurisdiction over the foreign domain names.
Yeah, don't.
I've not seen an order to an ISP to block a separate website. I suppose it's theoretically possible there may be First Amendment issues there, maybe all kinds of issues associated with that, but I've not seen that done.
I mean, technically it can be done because we know that we know that the internet backbones of other countries that have much more repressive regimes can block wholesale, websites or even whole chunks of the internet, and they do. So, I mean, it's possible to be done. I think that, really in this day and age, who can say, but hopefully that would be a short trip to court in the U.S.
Yeah, we still have the First Amendment, at least for now. Wait, we have one over here. Thank you. Yes, sir.
Websites and content put people out of business. It's another kind of asset forfeiture, extrajudicial, without any proof of trial.
Yeah, the concept of civil asset forfeiture or even criminal forfeiture prior to a finding of guilt is very controversial. There's movements to try to reform civil asset forfeiture, and basically the concept is that the government gets to go take your stuff before they can prove that you did anything wrong, or even without ever proving that you did anything wrong under civil asset forfeiture. And that seems contrary to all basic due process principles. But as it's evolved, more and more law enforcement agencies rely on that for funding and expectation of resources, and it's controversial. And so when it comes to a website, it's even more problematic because the speech that you're censoring is not only the speech of the website operator, but with these platforms, everybody else that uses it. So there's some tremendous First Amendment implications to seizing a website.
Okay. The notion of asset forfeiture is something where there's a lot of developed law behind it. You'll see different types of attempts to apply it in new ways. But if you look back to cases decided in the 1980s involving prohibitions of obscenity, where you had federal laws applying asset forfeiture to try and seize the assets of bookstores and seize books, films, things like that, the Supreme Court said that it is unconstitutional before conviction to engage in that kind of seizure. And as I say, there are attempts to do the same kind of thing now. We may be seeing more development of the law in that area, but the First Amendment doctrine in that area is pretty well established. I can't understand your question.
I mean, they're very confident, right? Of course, because they're bringing the lawsuit involved in it. I am extremely hopeful. The First Amendment is a very strong protection for freedom of speech and prohibits things like extremely overbroad laws that have criminal consequences that will lead to chilling effects, right? So there's, I highly recommend reading the briefs that have come out so far in the case. They're really good kind of overviews. I was just looking at the response to the motion to dismiss this morning, which is great weekend reading. But really, it's a very and not just to butter you guys up, but it's a really well done explanation of the 7 different ways that FOSTA creates new legal risk to hosting speech online. And that's, I hope, something that the courts are going to take seriously. The way that this bill has changed the entire landscape for hosting speech is pretty significant. It's the most significant change to the law around speech online since Section 230 was passed in '96, and since Reno versus ACLU in '97. It's really potentially changed everything we know about kind of what it means to be a website operator and how you kind of can operate in a world of limited risk while you're facilitating other people's speech online. So, CDT certainly plans to follow the case very closely and file as amici in the case. And I think one of the important things as the case progresses is to make sure, as I was saying earlier, that the voices of the people impacted by this are heard. And so there are some amazing plaintiffs in the case, including Woodhull Foundation, able to, and Human Rights Watch, a globally respected human rights organization, and some individual plaintiffs who have really compelling stories. And I hope that will have the court really take seriously what the really broad and kind of different sorts of consequences of this law really will be. But I think there will also be a lot of room, hopefully with consent of the plaintiffs, for amicus briefs that help to, build out the other stories and sort of show that this law will censor individuals. It will change the dynamics and the environment for talking about sex and sexuality online. It will change what it means to be able to run a website that hosts third-party content. I'm a free speech and internet optimist at heart, so I have to be optimistic, but I think it'll be the strongest case if we can really get as many of those stories before the court as possible.
One thing that we can't say for sure is that whatever happens at the district court level, the case is likely to go to the Court of Appeals, which in this case would be the U.S. Court of Appeals for the D.C. Circuit. If it follows the same pattern as previous litigations over internet regulations, it's likely to go to the Supreme Court as well. That was the case with the Communications Decency Act that ended in the Reno decision in 1997. It was followed up by the Child Online Protection Act, which was another version of the same kind of thing. It made 2 trips to the Supreme Court and then finally ended up in a subsequent Court of Appeals decision. Virtually all of the major laws affecting internet speech have followed that path.
And mentioning the Supreme Court, so there was recently the Packingham case at the Supreme Court, which I think is another kind of good indicator of how seriously the Supreme Court takes these issues. At issue in the Packingham case was a North Carolina law that really severely restricted the ability of people who were on parole and probation who had been convicted of sex offenses from using social media sites. And ultimately, so, talk about less than sympathetic plaintiffs, people who have been convicted of, in some cases, crimes against children, in other cases, sexual offenses like public urination. Part of the challenge, part of the problems with these laws is they lump a whole range of different kinds of offenses under the heading of kind of sex offender. But the court really took seriously the role of the internet in people's everyday lives, how important it has become to so many people for so many things, from political speech and talking to your representatives, commercial activity, religion, faith, dating, you name it. And so, I take that in general as a good sign that the court is ready to think carefully and seriously about just what it means to have a really broad brush approach to regulation of the internet. And, again, I'm an optimist, so I think that points in a good direction for us.
David, do you have a question?
One quick note. Emma mentioned that she was reading the opposition. All of the filings in the case, if you're interested in looking at any of them, are on the Woodhull's website at woodhullfoundation.org. So feel free to take a look. Yes, sir.
Sure. There are 5. You all know, obviously, the Woodhull Foundation and all the important work that it does, and who is our lead plaintiff in the case. We also represent Human Rights Watch, which is an international human rights organization that has done a lot of important work in exposing and reporting on human rights on a broad scale, including for sex workers around the world and in the United States. We represent the Internet Archive, which is the organization that does the Wayback Machine, that tries to catalog everything that is online so that you have it preserved in one spot, and who faces the prospect of liability because they can't monitor everything that they catalog. We have two individuals as well. We have Alex Andrews, who is with SWAP and does important work in trying to keep sex workers safe and advocating on behalf of sex workers. And we have Eric Kozik, who is a therapeutic massage therapist whose ads were completely blocked on Craigslist. He had made his livelihood for years being able to advertise on Craigslist, and when they closed down all of their personal ads and as well also professional services ads, he simply cannot get an ad accepted on Craigslist.
And they were all impacted a bit differently and have different types of claims to bring, but all are very negatively impacted by the law. There's a question in the back. So the question, and it's an excellent question, is how will this law, since it's so broad, affect artists who are producing their own content and publishing it, posting it on their websites, et cetera? How will it impact the artistic creative process? Want to take that one?
Well, so I think one kind of a consequence that we may see is the chilling effect, right? If people are concerned about this law being in place, what does that do as far as self-censorship goes, and kind of a disinclination to share your work and to kind of post it online because of concerns that you may attract the attention of a state attorney general somewhere. I think that is a real concern and will definitely hit some artists very hard. I think one of the biggest and probably most immediate consequences artists will face is that their art will be deemed too hot to handle by whoever is providing either hosting service or your domain name provider or payment processors. This is going to be a time when we all kind of realize once again how many different intermediaries are in that chain between us posting speech online and other people being able to see it. There are a lot of them, and if any of them become concerned about doing business with you or artists that you represent because there's nudity involved, because they're not sure what the Contact Me feature on the artist's webpage is really being used for, or if they're using algorithmic filtering to try to, keep themselves as in the legal clear as possible, and they're just taking down anything that might seem like it's possibly nudity. All of those are different things that we have already seen websites do, and I could anticipate a lot more of that, and having this kind of really broad collateral damage effect on all sorts of expression.
Yeah. Well, I was just going to say, here's the problem with broad laws like this. They kind of sit out there like a time bomb waiting to go off. I mean, you can look at this in one way and say, well, this is the anti-backpage law. This was adopted. It was a change in the law because the lawmakers wanted to go after a specific site, and so they adopted this law, and now Backpage is gone, so nothing to worry about, right? But look at the way Craigslist reacted to this. I mean, they've been out of the business of doing adult ads since 2010, and yet they, based on that experience, knew that this law, written the way it is, that can be applied as broadly as it can, is something that can become a problem for them in the future, even though they don't have an adult section or an escort section. It's the sort of thing that if the terms are broad enough, sometime down the road, if someone is motivated to prosecute or bring a civil claim, if they have the tool available to them, it's there and can be used. The chilling effect happens because a lot of people doing business online have had some experience with this, like Craigslist and others, and so they anticipate what could happen, and that's why they close down or modify their practices now.
Watch the water. And, speaking of Craigslist is a good example, they shut down adult and then this happens and they shut down dating. They shut down dating and things migrate to therapeutic services. They shut down therapeutic services. You know, we always say, you know, in the internet, content wants to be free. Well, you know, people want to have sex. They want to link up to have sex. They want to communicate to link up to have sex. It's going to go somewhere. I mean, you know, Backpage was seized by the government. They really, you know, as Bob said, they flipped the CEO and basically forced him to give over the website and the domain name and servers. But within a matter of days, I don't even know what to call it, a similar website called Bedpage popped up. Same exact layout, same exact content, same exact everything else. I mean, this content is always going to go somewhere, and the fact that you could face criminal liability if it winds up on something that maybe you would have never thought originally would lend itself to this, if it enables person-to-person communication, there's an opportunity for it to be used for illicit purposes just like it is for perfectly lawful purposes. And so service providers are really going to have no choice, but as things migrate, they're going to have to contract and contract and contract, potentially until, you know, user-generated content becomes a risk in of itself no matter what the substance is.
Other questions? Yeah, I mean, we've seen some evidence of that. You know, when you take down one platform, they've got to go somewhere. And so dating sites are particularly at risk for legal violations, and I know that a number of them are looking carefully at their compliance and moderation policies. But as Ronnie said, you know, what do you do? I mean, how do you actually comply with this law? Do you bar any mention of sexuality that is somehow tied to money, or just all mention of sexuality? What are going to be the moderation policies? And with the breadth of a law like this, you know, in order to be, quote, safe, you just have to eliminate, you know, the entire section, the entire site. So they're struggling for sure, and it's going to be tricky for them to develop those moderation policies, and they'll all come up with something different that is within their risk tolerance.
Yeah, and keep in mind, things aren't a problem until they are. And if you're looking at Congress adopting a law so that law enforcement can take a certain action, they're thinking sort of looking forward, what can we get rid of? If the target is Backpage, they pass a law, they want to go after that target. But civil liability operates in reverse, the possibility that someone may sue you down the road for something. There, something bad will happen, and plaintiffs' lawyers will look around, what tools can I use? How can I make this bad thing fit into a legal framework? And that's the problem of having a very broad law that creates very broad prospects of liability. It's very hard to plan for what may come because, I mean, millions of things happen to many different people.
And I had a very similar question, you know, as we were thinking about the impacts of SESTA and FOSTA. So I did some looking around for just like prostitution on dating apps and see what happens when you do a Google search for that, and found out there's a whole rampant debate among, you know, millennials using dating apps about whether putting in your profile, you know, $5 for a response, basically kind of setting a limit of, you know, a person posts an ad or posts a profile on a dating website and they get a lot of hits and they're just saying like, hey, look, you know, send me on Venmo $5 and then I'll actually, you know, deign to respond and have a conversation with you. I didn't know this was a practice at all, and went down an internet rabbit hole kind of looking up all of the, you know, rampant debate around does this count as sex work or not, and there's lots of, as you can imagine with any internet debate, a lot of really intense arguments on both sides. But, you know, you think about it from the dating app side of things, like they have no idea. They look at your profile and they see there's a link to like a PayPal or a Venmo. What are they going to do? What are they going to think? Are they going to think, oh, this is a way that people actually, you know, try to limit harassment that they face on my app and put a little bit of a opportunity cost into making a connection with somebody? Or are they going to think, oh, this puts me at risk for federal and state criminal and civil liability? Knowing lawyers for people who run websites, I'm guessing it's going to be the latter. So I think there is definitely a risk that a lot of these sites are going to have to be thinking through, and it's the sort of thing where even the most innocuous behavior on an app or a site can lead, you know, the person who's running the service to suspect that this is too risky and they should just shut it down.
And bear in mind that many of these criminal laws, the violation includes an exchange of quote unquote anything of value. It doesn't have to be money. I mean, a willing prosecutor or even a willing plaintiff's lawyer could characterize simple companionship as something of value, or a trade of services. It's almost infinite.
One of the cases that we dealt with earlier had a state law that had a similar provision prohibiting ads that had a thing of value as the triggering mechanism. The court explained in striking down the law that could be a promise to do the dishes, it could be a promise of a nice dinner, anything that could be considered a thing of value could lead to legal liability.
Another category of sites that are struggling with this is the live webcam sites, because there's already a commercial transactional relationship there, and so they're struggling with, how do we prevent people from agreeing to meet in real life, and do we have to now do that and prevent anybody from actually forming relationships in order to protect ourselves from the allegation that our site is being used to somehow facilitate prostitution? Any other questions? I guess we're getting close to our time, but we can fit maybe one or two more in. Everybody good? All things FOSTA? All right, well, we really appreciate you coming and your attention, and follow along on the case, and thank you, and feel free to talk to us afterwards.